Edmonds.
Here.
Gant.
Here.
Grant. Foster. Masula.
Here.
Lakin.
Here.
Rizzo. Snyder.
Here.
Trabuzzi.
Here.
Woodson.
Yeah.
Yarkowski. Quorum is present.
Thank you. Thanks, Sabrina. As we begin the meeting, I ask everyone to silence your cell phones. Welcome everyone to our final meeting of this session. I figured, why end it boring? So we're going to go ahead and get started with HB 1337, Step into Success, Workforce Education and Internship Pilot by Representative Oberdorf. Representative Oberdorf, you're recognized to explain your bill.
Thank you, Mr. Chairman. HB 1337 creates Step into Success Act. This act creates a 3-year pilot program that provides an opportunity for current and former foster youth to receive career counseling, mentorship, and a paid internship. The act provides a pathway for foster youth to transition from the custody of the Department of Children and Family into independent living. Members, that is the bill.
All right, members, are there any questions on the bill? All right, seeing none, there are no amendments, there is no public testimony. Is there any debate? Seeing none, you're recognized to close on your bill.
Wait closed.
All right, having closed on this bill, Sabrina, please call the roll on HB 1337 and announce the vote.
Representatives Persons Maleka, excused. Salzman.
Yes.
Skidmore.
Yes.
Amnesty.
Yes.
Anderson.
Yes.
Baker.
Yes.
Clemens.
Yes.
Cross.
Yes.
Dunkley.
Yeah.
Edmonds.
Yes.
Gant.
Yes.
Grant.
Yes.
Coster. Masula.
Yes.
Lakin.
Yes.
Rizzo.
Yes.
Snyder.
Yes.
Trabuzzi.
Yes.
Woodson.
Yes.
Yarkowski.
Yes.
Chair Hahn.
Yes. 19
yeas, 0 nays.
All right, show that bill reported favorably. Congratulations. Thank you. All right, next up, we are going to take, all right, we're going to do Representative Hawkins. You were waiting. Come on up for CS for HB 1567, Elder and Vulnerable Adult Abuse Fatality Review Teams by Representative Hawkins. I would note, members, there's a strike call and you're recognized to explain your bill.
Thank you, Mr. Chairman. Members, honored to be with you today to present House Bill 1567. This legislation is about looking into fatal cases of elder abuse, neglect, exploitation, to see what we can learn from them in order to make better informed policy decisions to prevent these types of deaths from occurring in the future.
Okay, members, are there questions on the bill before we get to the strike call? Seeing none, you're recognized to explain amendment barcode 467851.
Thank you, Mr. Chairman. This is a strike-all amendment, removes the term near fatal, clarifies the meaning of elder vulnerable adult to incorporate the terms vulnerable adult as defined in Chapter 415, as well as disabled adult and elderly person as defined in Chapter 825. It requires the initiating entity to design or to designate a representative to serve as a co-chair on the review team, restricts the geographic area served by the review team to the bounds of the service area jurisdiction of the initiating entity, requires review team members to sign an acknowledgement of their responsibilities regarding the management of public records and those records exempt from public record requirements.
Members, are there any questions on the strike call? Yes, Representative Gant, you're recognized for a question.
Thank you, Mr. Chair. Good afternoon, Representative Hawkins. My question is about the discovery portion, lines 212. It begins at 212 and it ends about 228. So subsection 9A says that the records acquired by the review team are not subject to discovery in criminal, civil, administrative, disciplinary proceedings. Can you just give me a little clarity on that? Was the information just compiled for research purposes for recommendations?
You're recognized.
Thank you, Mr. Chair. That's a great question. The review teams aren't established for civil or criminal prosecution. These are more to review, bring policy back to the legislature in the future.
Follow up? No. Okay. Additional questions? All right, there are no amendments to the amendment. There is no public comment. Members, is there anyone wishing to debate the amendment to the amendment? All right, seeing none, we'll show that amendment adopted without objection. We're back on the bill as amended. You have a few comment cards. Brian Jogers with Florida Bar's Elder Law Section, waves in support. Thomas Parker with the Florida Healthcare Association, waves in support. Karen Murillo with AARP, waves in support. And Barney Bishop with the Florida Smart Justice Alliance, waves in support. Members, is there anyone wishing to debate? All right, seeing none, I just would say, bills that try to help figure out what goes wrong when someone who's elderly and is in and being cared for by somebody else when something goes wrong, trying to figure that out is a noble exercise, and I'm glad we've been able to get this bill up, and I'm excited for you to present it. You're recognized to close.
Mr. Chairman, just in my close, I'll just say thank you to the staff for getting this bill in the proper form that we can hear today. That's what I'll close by.
All right. Having closed on this bill, Sabrina, please call the roll on HB 1567 and announce the vote.
Representatives Persons Malika, Salzman,
Yes.
Skidmore,
Yes.
Amnesty,
Yes.
Anderson,
Yes.
Baker,
Yes.
Clemens,
Yes.
Cross,
Yes.
Dunkley,
Yeah.
Edmonds,
Yes.
Gant,
Yes.
Grant,
Yes.
Foster, Masula,
Yes.
Lakin,
Yes.
Rizzo,
Yes.
Snyder,
Yes.
Trabuzzi,
Yes.
Woodson,
Yes.
Yurkowski,
Yes.
Fairfine,
Yes.
19 yeas and 0 nays.
Show the bill reported favorably as amended. Next up, we've got your companion bill, 1569, the public records and meetings exemption for elder and vulnerable adult abuse fatality review teams. You're recognized to explain your bill.
Thank you, Mr. Chairman. This bill addresses public records and sunshine law exemptions for the records and case review discussions of fatality.
And we do have a strike all, but before we get to that, members, are there any questions on the bill? All right, seeing none, we're going to take up a strike all, but amendment, barcode 271385. You're recognized to explain your amendment.
Thank you, Mr. Chairman. This amendment lines up the language in the bill with Senate language.
All right, members, are there any questions on the amendment? Seeing none, we have no public testimony on the amendment. Is there any debate? Seeing none, we're going to show that amendment adopted without objection. We're on the back on the bill as amended. Barney Bishop with the Florida Smart Justice Alliance is a proponent, waves in support. And Karen Murillo with AARP, waves in support. Members, is there anyone wishing to debate on the bill? All right, seeing none, you're recognized to close.
Waive close.
All right, having waived close, Sabrina, please call the roll on HB 1569 and announce the vote.
Representatives Persons Malika, Salzman,
Yes.
Skidmore,
Yes.
Amnesty,
Yes.
Anderson,
Yes.
Baker,
Yes.
Clemens, Cross,
Yes.
Dunkley,
Yeah.
Edmonds,
Yes.
Gant,
Yes.
Grant,
Yes.
Foster, Masula,
Yes.
Lakin,
Yes.
Rizzo,
Yes.
Snyder,
Yes.
Trabuzzi,
Yes.
Woodson,
Yes.
Yurkowski,
Yes.
Fairfine,
Yes.
19 yeas, 0 nays.
Show the bill reported favorably as amended. Next up, we're going to have, congratulations. Next up, we're going to have CS for HB 1481, sickle cell disease medications, treatment and screening by Representatives Driscoll and Campbell. You're recognized to explain your bill.
Good afternoon. Ooh, no, that's two. Good afternoon, Mr. Chair and members. It's an honor to introduce to you House Bill 1481. Florida has the highest number of sickle cell births nationwide. However, data for that population is severely lacking, and that hinders the ability to better inform patients about treatment options and available resources. And this bill, in part, is encouraged to try to rectify that. House Bill 1481 requires Florida Medicaid to conduct an annual review of all medications, services, and treatments available for individuals living with sickle cell disease. The purpose is to determine if the available covered medications, treatments, and services are adequate to meet the needs of and to see if ACA should seek to add or recommend additional medication, treatments, or services. Although rare, sickle cell is the most common inherited blood condition in the U.S. Patients are predominantly insured by Medicaid, over 45% or so of the beneficiaries are on state Medicaid rolls. And this review would seek input from persons or groups with knowledge in sickle cell disease treatment. The bill attempts to utilize the current Medicaid encounter data for implementing and collecting this information. Using this existing network will help reduce the need for additional work. And most importantly, this report can be used as a tool for advocacy groups to continue to raise awareness with patients. The other portion of the bill creates the Sickle Cell Disease Patient Registry. The purpose of the registry is to enable individuals diagnosed with sickle cell disease to register so that physicians and other healthcare practitioners providing care to the patient may confirm whether the individual has been diagnosed with sickle cell disease and to collect and study data on the incidence and nature of sickle cell disease in the state to improve patient care and access to services. And that, Mr. Chair, is the bill.
All right, members, are there any questions on the bill? Seeing none, we do have one amendment. It's not a strike all. It's barcode 475673 by Representative Woodson. Representative Woodson, you're recognized to explain your amendment.
Thank you, Mr. Chair. This is a simple amendment that asks to remove lines 132 to 158 and insert the following language: appropriated for the Agency for Healthcare Administration for the purpose of implementing this act. That's the amendment, Mr. Chair.
Thank you. Are there questions on the amendment? I'll ask the first one to the bill sponsors. This is a friendly amendment.
Yes, thank you. It gets the bill in the posture that it needs to be and removes some redundant language from a prior language and proviso.
Okay, thank you. Members, are there additional questions on the amendment? Okay, seeing none, we don't have any public testimony on the amendment. Is there any debate on the amendment? Seeing none, show the amendment adopted without objection. We have no public testimony. Members, is there anyone wishing to debate? Representative Gant, you're recognized in debate.
Thank you, Mr. Chair, for your recognition. I want to say thank you to both sponsors of this bill. Before my little cousin passed away at 20, she had sickle cell, and every single birthday we celebrated like it could have been her last. And my family, we just didn't have a lot of information on it because it was the first time anyone in my family had sickle cell. So I know that this bill and what its intended purpose is going to help a lot of families, including mine, because the trait does run in our family. So thank you for this very important bill.
Representative Woodson, you're recognized.
Thank you, Mr. Chair. Leader Driscoll and you know your name. I'm just kidding. Campbell, I'm just messing with Campbell. We don't have time to mess this afternoon, but this is a very good bill. I have one clinic in my area, and I go there and see the patients who suffer from sickle cell anemia, and it's really a tragic disease just to look at what they're going through in their families. And I know this bill would do a lot of good because we have so many people suffering from sickle cell anemia. Not only that, that's a disease that impacts the Black community more than any other one. So I appreciate both of you work on this bill, and I look forward to support you, my colleague and I, to support you on this bill. Thank you.
Additional debate? All right, seeing none, I just would say this to the folks out there, particularly those cameras. Don't say we never work together, because here we are. With that, you're recognized to close.
Thank you, Mr. Chair. And, as we were presenting this bill and doing the research that we need to get into the posture that we need to be, a lot of situations, a lot of people have been coming forward and telling us their stories about how sickle cell disease and sickle cell trait has impacted their lives. And so just even in the small instances of us doing that, this bill impact will have great magnitude just off of all Floridians. And so I'm excited for what is to come forth and the numbers and amount of help that we're providing towards the individuals struggling with this disease and knowing that they have the trait as well. And so I'm excited. I ask that you co-sponsor this bill when you get a chance and vote up here so that we can continue to see individuals get the care, the treatment, and the education that they need on sickle cell disease and sickle cell trait.
All right, Sabrina, please call the roll on CS for HB 1481 and announce the vote.
Representatives Persons Malika, Salzman,
Yes.
Skidmore,
Yes.
Amnesty,
Yes.
Anderson,
Yes.
Baker,
Yes.
Clemens,
Yes.
Cross,
Yes.
Dunkley,
Yeah.
Edmonds, Gant,
Yes.
Grant, Foster,
Yes.
Masula,
Yes.
Lakin,
Yes.
Rizzo,
Yes.
Snyder,
Yes.
Trabuzzi,
Yes.
Woodson,
Yes.
Yarkowski,
Yes.
Chair Fine,
Yes.
20 yeas and 0 nays.
Show the bill reported favorably as amended. Congratulations. You're welcome. All right, next up, we are going to have Representative Steele present HB 601 regarding patients by healthcare providers. Representative Steele, you are recognized to explain your bill.
Thank you, Chair, Vice Chair, Ranking Member, and Committee. I'm honored to be here to talk to you about HB 601. It is changing and removing the definition of a direct supervision and in office and replacing it with Medicare required rules.
Okay, having presented this bill, members, are there questions on the bill? Okay, there are no amendments. We do have some public comment card. James Eaton, representing Millennium Physician Group, is a proponent and wishes to speak.
Waive in support.
Waves in support. All right, ending public testimony. Anyone wishing to debate? Seeing none, you're recognized to close.
Waive close.
All right, Sabrina, please call the roll on HB 601 and announce the vote.
Representatives Persons Malika, Salzman,
Yes.
Skidmore,
Yes.
Amnesty,
Yes.
Anderson,
Yes.
Baker,
Yes.
Clemens,
Yes.
Cross,
Yes.
Dunkley,
Yes.
Edmonds,
Yes.
Gant,
Yes.
Grant,
Yes.
Coster,
Yes.
Masula,
Yes.
Lakin,
Yes.
Yes.
Trabuzzi,
Yes.
Woodson,
Yes.
Kirkowski,
Yes.
Chair Fine,
Yes.
20 yeas and 0 nays.
Show the bill reported favorably. Congratulations. All right, oh, here he comes. Come on over. Hurry, hurry. You're next up. All right. As he walks in, we're going to take up CS for HB 1007, Children Removed from Caregivers by Representative Barrero. You're recognized to explain your bill. Did I catch you off guard? You not ready?
I hope I had an honorable entrance.
There you go.
Thank you, Chairman. So it's House Bill 1007. It requires that a trauma screening be issued to children that are removed from caregivers to identify trauma as a result of children being removed from their home. That's the bill.
All right, members, there is a strike all, but are there any questions on the bill? All right, seeing none, we're going to bring up a strike all amendment barcode 488803. Representative Barrero, you're recognized to explain your amendment.
Thank you, Chairman. The amendment outlines in a little more detail the next steps after a trauma screening. It lengthens the time to 21 days to provide the trauma screening and ensures the child gets a follow-up assessment afterwards.
All right, having explained his amendment, are there questions on the amendment? Seeing none, we do a little public testimony on the amendment, the strike all. Caleb Hawks with the Florida for Coalition for Children waves in support. Members, is there anyone wishing to debate on the amendment? All right, seeing none, you're recognized. Well, we're gonna show that amendment adopted without objection. We're back on the bill as amended. Public testimony, Barney Bishop with the Florida Smart Justice Alliance, waves in support. Karen Mazzola with the Florida PTA, waves in support. Members, is there anyone wishing to debate on this bill? All right, seeing none, I would just say, it's, again, a noble cause. A kid who's gone through this sort of trauma, we ought to be doing everything we can to help them and make sure they come out right on the other side. So thanks for your hard work and your Senate sponsor, my friend, Senator Yarborough, and with that, you're recognized to close.
Chairman, fine, you took the close out of my mouth.
All right. I had a close thrown at me this week, so all right. Sabrina, please call the roll on CS for HB 1007 and announce the vote.
Representatives Persons Mullica, Salzman,
Yes.
Skidmore,
Yes.
Amnesty,
Yes.
Anderson,
Yes.
Baker,
Yes.
Clemens,
Yes.
Cross,
Yes.
Dunkley,
Yes.
Edmonds,
Yes.
Gant,
Yes.
Grant,
Yes.
Coster,
Yes.
Masula, Lakin,
Yes.
Rizzo,
Yes.
Snyder,
Yes.
Trabuzzi,
Yes.
Woodson,
Yes.
Kirkowski,
Yes.
Chair Fine,
Yes.
19 yeas and 0 nays.
All right, show the bill reported favorably as amended. Congratulations.
Thank you very much.
Walk out with the same style you walked in out. So, all right. Well, while we do have additional bills from members who are not members of the committee, we're going to move on to bills that are by members of the committee while we wait for them. We'll first take up CS for HB 1021 regarding child care and early learning providers by Representative McFarland, but as she is out on maternity, it's going to be presented by Representative Trabulsi. Representative Trabulsi, you are recognized to explain Representative McFarland's bill.
Thank you, Mr. Chair. I have a strike all amendment, and in the essence of time and the multitude of components we took out of the original bill, would you like to take out the strike all?
Okay, that's fine. Before we do that, members, are there any questions on the pre-strike all bill? All right, seeing none, we're going to take up amendment barcode 283845.
Thank you, Mr. Chair, and thank you, members. On behalf of Representative McFarland, I'm pleased to present this bill. As some of you know, working families with young children are struggling to afford the high cost of child care throughout our state. This bill takes a multi-pronged approach to hopefully help reduce the cost of child care. It updates insurance regulations to include large family care homes. It creates opportunities for VPK providers to onboard staff. It allows coalitions to receive increased VPK administrative dollars to support the program. It allows the department to commission a statewide early learning curriculum that will be available free of charge and may be used voluntarily by early learning providers. It requires the state to establish a new comprehensive early learning technology platform to reduce the burden to providers from having to access 6 different systems to participate in the state's early learning programs. It allows for coalitions to add a member from law enforcement to their board. Composition clarifies spending for early learning coalitions. Aligns language on violations for Gold Seal to changes made to language regarding violations in the child care licensing section of statute. and creates a 140-hour summer bridge program for VPK students who are not demonstrating readiness for kindergarten. And that is the bill, Mr. Chair.
All right, having explained the strike-all amendment, members, are there any questions on the strike-all amendment? Okay, seeing no questions, we do have one public comment. David Daniel with the Florida Association for Child Care Management waves in support. Is there debate on the strike-all amendment? Seeing none, we'll show that amendment adopted without objection. We're back on the bill as amended. Sarah Catherine Massey with the Florida Chamber of Commerce waves in support. And Michelle Watson, representing the Florida Alliance of Children's Councils and Trusts, Inc., also waves in support. Members, anyone wishing to debate? All right, seeing none, you're recognized to close.
I'll waive close, Mr. Chair.
Okay, Sabrina, please call the roll on CS for HB 1021 and announce the vote.
Representatives Persons Malika, Salzman,
Yes.
Skidmore,
Yes.
Amnesty,
Yes.
Anderson,
Yes.
Baker,
Yes.
Lemons,
Yes.
Frost,
Yes.
Dunkley,
Yes.
Edmonds,
Yes.
Gant,
Yes.
Grant,
Yes.
Coster,
Yes.
Masula,
Yes.
Bacon,
Yes.
Rizzo,
Yes.
Snyder,
Yes.
Trabuzzi,
Yes.
Woodson,
Yes.
Yurkowski,
Yes.
Carafon,
Yes.
20 yeas and 0 nays.
All right, show the bill reported favorably as amended. We are cranking through this, guys. All right, next we're going to take up CS for HB 1557, sexual exploitation and human trafficking by Representative Salzman. Representative Salzman, you are recognized to explain your bill.
Thank you, Mr. Chair. This bill is for human trafficking victims. It does a few things to expand on the state's ability to actually hold some of these agencies and persons accountable, Mr. Chair.
Okay, thank you. Having explained your bill, are there, we do have a strike-all on this bill, but before we do that, are there questions on the pre-strike-all bill? Seeing none, we'll take up Amendment Bar Code 2838. Nope, I'm on the wrong one. Sorry.
It's okay.
I moved in too fast. Okay, I got it. No, give it. All right, Amendment Bar Code 507685. You recognize to explain your amendment.
Thank you, Mr. Chair. This amendment just adds a requirement for a study on adult safe houses by the statewide Council on Human Trafficking Services and Resources Committee, which is chaired by the DCF Secretary. It'll basically provide for some guardrails on the requirements that we will be putting in place for the adult safe houses to keep these survivors safe.
Okay, having explained the strike-all amendment, members, are there questions on the strike-all amendment? Seeing none, we have no public testimony. Members wishing to debate? Seeing none, we'll show the amendment adopted without objection. We are on the bill as amended. Barney Bishop with the Florida Smart Justice Alliance waves in support. Libby Guzza with the Office of Attorney General waves in support. And Karen Mazzola with the Florida PTA waves in support. Members, is there anyone wishing to debate? Okay, seeing none, you are recognized to close on your bill.
Thank you, Mr. Chair. I'd just like to close by saying this bill attempts to stop the scourge of human trafficking by stopping the victimization, or in some instances, re-victimization of vulnerable adults and children by traffickers. And it just builds on the already robust human trafficking laws by doing those things mentioned before. Thank you, Mr. Chair.
All right, Sabrina, please call the roll on CS for HB 1557 and announce the vote.
Representatives Persons Malika, Salzman,
Yes.
Skidmore,
Yes.
Amnesty,
Yes.
Anderson,
Yes.
Baker,
Yes.
Lemons,
Yes.
Frost,
Yes.
Dunkley,
Yes.
Edmonds,
Yes.
Gant,
Yes.
Grant,
Yes.
Coster,
Yes.
Masula,
Yes.
Lakin,
Yes.
Rizzo,
Yes.
Snyder, Trabuzzi,
Yes.
Woodson,
Yes.
Yurkowski,
Yes.
Carafon,
Yes.
19 yeas and 0 nays.
All right, show the bill reported favorably as amended. All right, seeing no additional bill sponsors here that are not members of the committee, we're going to move on to not a bill. And so we are going to be, let me get to it. We're going to be discussing the investigation and of the adoption and endorsement of, quote, gender-affirming care, end quote, as the standard of care for minors, and consideration of the issuance of subpoenas for records. As I will be the one making the introduction and the motion, I'm going to hand the gavel over to my partner on these issues, Representative Masula, who will chair this part of the meeting. Chairman Masula, there you go.
Thank you, Chair Fine. You're recognized to introduce the next item on the agenda. which I think you already have, so you are now recognized for a motion.
Thank you. First, I'm going to make a few remarks and refer the members to the speaker's letter. Members, as you saw in the package of materials for today, actually went out with the agenda. The speaker has sent me a letter asking us to investigate the standards that have been created for the development of so-called gender-affirming care. There's been a lot of discussion about it as we've gone through these bills. Yet there's not a lot of insight into how these things were created, the organizations that supported it, and the science behind it. So he has asked us as a committee to look into these issues and to consider issue subpoenas to Florida entities that have used so-called consensus science in order to support these things. So I will be shortly moving that we adopt subpoenas requiring the provision of materials related to these issues.
Members, do we have any questions? Yes, now you're recognized for your motion.
Thank you, Mr. Chairman. I move that the committee approve the issuance of subpoenas that I will create and sign for documents and records from the Florida chapter of American Academy of Pediatrics, Inc., and the Florida Psychiatric Society, a district branch of the American Psychiatric Association, Inc.
Now, members, any questions?
I object to the motion, Mr. Chair.
And state why you would object.
I object to the motion because I do not feel that it is pertinent to the compelling interest of the state. In addition, we have already passed legislation concerning this matter, and it seems redundant and out of order.
Representative Gant, we're going to confer with staff. All right, the House is authorized under Rule 16.1 to issue subpoenas for documents, and we will proceed with that, and your motion is out of order. We have further questions? Representative Cross, you recognize the question.
Thank you for the recognition, Mr. Chair. Noticing in the letter from the speaker, it mentions that ACA has attempted to get some of this information as part of litigation. Is it appropriate for this legislative branch to be doing work for the executive branch?
Sure. Fine, you recognize.
Thank you. ACA's not the only one who's trying to get this. Many entities have been trying to get this information without success. We're not doing the work for the executive branch. We're doing the work for the House, for the Speaker, and for me.
Further questions? Rep. Skidmore, you recognize.
Thank you, Mr. Chair. Rep. Fine, given that the function of the committee is to provide oversight of state agencies, is the committee also going to investigate the process by which ACA developed its report and adopted the rule banning coverage of gender-affirming care? And if not, why not?
Chair Fine, you recognize.
Thank you. That's not the subject of my motion. My motion is about issuing subpoenas to these entities here today.
Rep. Edmonds, you're recognized.
Thank you, Mr. Chair. Normally, the legislator engages in investigation and fact-finding before legislating, not after. The House has already passed a bill which you expect that will become a law, and it rejects the standards of care you want to investigate with these subpoenas. Why did we change the law first and investigate second? Can you give me an example where the legislator has done this in this order before?
Rep. Edmonds, can you ask one question at a time? What's your first question?
Why did we change the law first and investigate second?
Rep. Fine, you recognize.
Thank you, Mr. Chairman. We have not changed the law yet.
Rep. Edmonds, your second question? Go ahead.
Can you give me an example where the legislator has done this in this order before?
I think he already said that we haven't changed the laws yet. So do you want to rephrase your question?
So what I'm asking, this is a law that is about to go into effect that we passed.
Rep. Edmonds, the governor has got to sign the law. We have to see if the Senate is going to concur with our bill that we've sent over to them. So I believe we're just trying to find more information to support our case at this point in time.
Okay, my question is simple. Why didn't we investigate first?
You recognize.
Thank you, Mr. Chairman. We did a thorough investigation as part of this committee. We had a hearing where we brought in scientific experts. But one of the things that we've heard over and over and over again is that it is much like we've heard with things like COVID. Everyone agrees, it's universally accepted and that sort of thing. And so we figured if this is going to be an ongoing issue, I think that this committee and the state continues to address. And so it's something that the speaker asked us to look into. And so that's why I'm making this motion today.
You're recognized for follow-up, Rep.
Thank you, Rep. Fine, and thank you, Mr. Chair. Do you have an example of this occurring before in this order?
And you're recognized. I think that's been asked and answered. Do you want to try it again?
No.
Rep. Whitson, you're recognized for a question.
Thank you, Mr. Chair. Chair Fine, did you invite the groups and individuals targeted by these subpoenas to testify before the committee? And did they accept your invitation or decline it?
And you're recognized.
Thank you, Mr. Chairman. No, we did not invite them, but all we're doing is asking them for the information that justifies the views that they have put forward. One would believe that if they have nothing to hide, they won't hesitate to provide that information that shows the extensive and lengthy scientific basis, that shows the uniformity of opinion and why all the countries that are in Europe, which are going the other direction, are completely wrong and everything else. I would think they would welcome the opportunity to do this.
You have a follow-up, Rep. Whitson? You're recognized.
Thank you, Mr. Chair. Since we have, is there a specific reason why we haven't bothered to ask them to speak to us before?
You're recognized. You're fine. I think he's answered.
No, it's fine if you want me to. I mean, I guess what I would say is this. Chair Masulo's and my bill went through 3 committees, I think. I think Senator Yarborough's bill is on this subject, went through multiple committees in the Senate. Those and any other entities would have had the opportunity to come and speak in public testimony at any of those opportunities to justify why this is all such great stuff that they're pushing on our children.
Rep. Gant? Rep. Gant, you're recognized for questions.
Thank you, Mr. Chair. Thank you, Mr. Chair, for recognizing me. Chair Fine, are these subpoenas targeted to only individuals or groups or groups with a physical presence in Florida, or are we going to be extraterritorial in our information gathering?
Rep. Gant, I think you recognize that the subpoenas are for 2 individual Florida groups in his explanation. Would you want to elaborate on that?
Yeah, I think that's a fair question. No, these subpoenas are for Florida entities, not entities outside of Florida. We recognize those limitations, and so no, these are 2. If we had that, I'll say this: if we had the ability to go outside of Florida, we certainly would, but we do not, and so they're limited to Florida.
You have a follow-up?
I do.
You're recognized.
Thank you, Mr. Chair, for that recognition. For clarification, the entities that you've identified as being in Florida, are they headquartered in Florida, or are they do they simply have a presence in Florida?
Thank you.
You're recognized.
Thank you, Mr. Chairman. I don't know the answer to that. I mean, I would presume the Florida chapter of the American Academy of Pediatrics, I'm guessing, is not headquartered in Florida. The chapter of, well, the Florida chapter is headquartered in Florida, but the American Academy, I don't know where they're headquartered, but I wouldn't expect it to be here. The Florida Psychiatric Society is headquartered in Florida, but they're a district branch of the American Psychiatric Association, which I would presume is not headquartered in Florida. But both of these entities are headquartered in Florida, and they have registered agents to which we will deliver this.
You're recognized for a follow-up.
Thank you, Mr. Chair, for that recognition, and thank you for that response, Chair Fine. So this will be my last follow-up question regarding the status of whether it's in Florida or not. So are we requesting records that could be part of the national organization's standard operating procedures? And if so, how would that subpoena power work if that is a part of their national organization structure and they are headquartered outside of the state of Florida?
You're right. Thank you, Mr. Chairman. The subpoenas will be to the Florida entities. So much like when we're issued ask for a public records request between us and someone else. We have to provide those records that are between us and that other group. That would be the same here, but the recipient of the subpoena would be those two entities that are Florida-based.
Did you have another question? You recognize?
Thank you,
One
Ms.
last time.
Okay,
Because you said that was your last one.
well, it was the last one that follow-up.
All right, I recognize.
On that family of questions, thank you, Mr. Chair, for your recognition. Regarding the fiscal part of the issuance of the subpoenas, is there, or what is the anticipated fiscal for taxpayers to serve and enforce the subpoenas?
Thank you. The fiscal to serve the subpoenas is negligible. To enforce the subpoenas, I guess, would be dependent on whether the entities chose to fight the subpoenas, but we would presume that they would recognize the Florida legislature's subpoena power. Nope. But assuming that they comply with the subpoenas, I don't think there's much of a fiscal to do it. And by the way, while I haven't seen this exact situation, I have been part of committees that have issued subpoenas in the past. This is not an unheard of thing for us to do.
I'll allow you one more question.
Okay, I have two more questions, so can I circle back?
You can circle back.
Okay, thank you, Mr. Chair, I appreciate that. So I know that in doing research about this whole process that there have been instances where subpoenas have not been complied with. And since we're being asked to authorize them today and failure to comply could result in a due process issue of life and liberty, meaning imprisonment or a monetary fine, what constitutional protections will we afford the organizations that are the subject of the subpoenas?
You're recognized, Chair Fine.
That's a fair question. So your question is what happens if they don't comply? What we can do is we can hold them in contempt of the Florida House of Representatives and punish them in accordance with Article 3, Section 5 of the Florida Constitution, Section 11.143 of the 11.143 of the Florida statutes, and applicable rules of the House. So there are rules and there are processes and there are procedures, and their constitutional rights will be protected.
And your last question, you recognize.
Last question. Oof. I have so many. Okay. So my last question, and I would, if possible, like another shot at this. So has the state's motion to compel these organizations to produce records being resolved? Because it's my understanding that there's currently ongoing litigation in federal court to which Florida is a party.
You recognize.
I'm sorry, would you repeat the question?
I
apologize.
repeat the question.
Okay, no problem. My question is, as noted in the speaker's letter, this issue is part of an ongoing federal litigation, and Florida is a party to the ongoing federal litigation. So has the state's motion to compel these organizations to produce records been resolved? And how, well, that's the first question I asked. I have more.
And I'm going to apologize one more time. There's a lot going on over here. Give her an extra question since I'm making her ask it 3 times. Can you say it one more time? I apologize.
No problem. 3 times a charm. So in the speaker's letter, the issue, or this particular issue that's the subject of this investigation, is part of ongoing federal litigation. In that ongoing federal litigation, Florida is a party. And the state's motion to compel these organizations to produce records is a current pending motion. Has that motion been resolved?
Thank you. Okay. Thank you. I understand the question. So the state is party to litigation, and that is, an executive branch function. But we, assuming this committee agrees on this committee and in the Florida House, believe that we are also entitled to examine this information as part of it. I will note that these organizations have been extremely unwilling to share this information. And they have multiple states and multiple proceedings have tried to obtain it, yet again, despite the fact this is good and great and universally accepted and incredibly scientifically proven and no one has any doubts whatsoever that they have fought to provide it. This is just going to be another front in that desire to get at this information. But we have the right as an independent branch of government to issue these subpoenas, and that is our intent here today.
Very good, we're gonna move on. Rep. Dunkley, you're recognized for a question.
Thank you, Chair Masulo. Chair Fine, I just have one question. Curious, are we only targeting groups that support the standard of care?
You're recognized.
Thank you. We are sending these subpoenas to groups that have made claims about a broad-based, scientifically backed, universal standards of this so-called gender-affirming care to understand the basis upon which that they make those claims. And so we are not targeted, to use your term of targeting, not all of them, because not all of them have Florida entities, but those that do, that are repeatedly used as justification for this, and to say that if you don't follow them, you don't agree with science. Well, we want to see the science that justifies this view.
Further questions, members? Any further questions? Yeah, well, you have a question, Brady? Yes, you're recognized and then
Thank you, Mr. Chair. Because we don't have the text of the subpoenas in front of us to look at, Chair Fine, what are you expecting to do with the information we get?
You're recognized.
That's a great question. Again, this vote authorizes me to prepare and execute the subpoenas, and that is our process. But the information that comes back will be analyzed by this committee, and I would presume that would include all of you. So the idea is to bring into the light the so-called universally accepted, unambiguous, clear-cut evidence that supports these things. Frankly, I find it shocking that we have to have a subpoena to do this. If I was someone who was so confident in my views on science in the world, I'd certainly be happy to share it. But these organizations, for whatever reason, are unwilling to, and so we're going to make them.
Rep. Gant, you're now recognized for your last question.
Last, oh Lord.
I did ask you to bring it up.
Okay, thank you.
All right.
Thank you, Mr. Chair, for your recognition. So, in regards to the pending motion to produce that's in federal court, we haven't seen the text of the subpoena, so I have no idea what the subpoena is searching for. So, would our subpoena be circumventing in some way the records that are being requested in the pending motion before the court, because we don't actually know what we're asking for? And will the information being sought overlap in some type of way where we will be, in effect, crossing over into the executive branch and what that ongoing case is doing right now? Because I have no idea.
Rep. Gant, I believe he already answered that there are two separate issues, and we're using our authority as members of the legislature to have subpoenas on information that we want unrelated to the executive branch. Do you have anything to add, Chair Fine?
No, I would say, look, sometimes there's multiple ways to get at information. You could have to provide information, not outside of this because of public records requests. You could have to provide that same information because you got sued, for example. There's often multiple ways to get at existing information. We recognize that there are multiple other entities, there are multiple states, there may be the executive branch that are trying to get at similar information. They have not as yet been unsuccessful. We want to know, if the committee votes with me, we want to know, we have a right to know, and so we're going to ask. And our decision to pursue that information has no bearing or jurisdiction on what others so choose to try to gather on their own.
And respectfully, Mr. Chair, thank you. I asked about the scope of the subpoena because we haven't seen the text, so I don't know what the scope of the subpoena would be versus what is already being compelled by the parties in the ongoing litigation. So that was really my question.
Thank you. I believe he explained the scope of what the subpoenas will entail, but you're welcome to add anything, Chair Fine.
Thank you. And while I recognize that you might have the desire to have the subpoenas and argue about them, this is not a bill. This is not where I put up a subpoena for consideration and people can say, well, let's take out this line and take out that line. Under the rules of the Florida House, this committee has to vote to give me the authority. I would be the one writing the subpoena along with staff and legal expertise. I'd be the one executing that subpoena along with witnessed by the speaker and putting it forward. And so if you trust my judgment in order to do that, which I think some would, then you'll probably support this. If you don't trust my judgment, which I would expect some would, then you won't. But under our rules, that is how this works. The request to file a subpoena is not like a bill. It does not go through that same process. This authorizes me to file the subpoena, I think best in my judgment, and assuming I can get it approved by the speaker. So it's really up to me, frankly, it's up to me and the speaker. I create the subpoena, I sign the subpoena, I give it to the speaker, he approves it, and then it's off to the races. It actually gets attested by the clerk, but he doesn't get any say over it. He just, I guess, makes sure he knows it's us, and then off it goes. That is our process, whether we like it or not.
Rep. Cross, you recognize.
Thank you for the recognition, Mr. Chair. Chair Fine, when Ranking Member Skidmore asked about the subpoena, you mentioned this would be forthcoming, but that this body may be involved at some point. Can you outline what the potential timeline would be and how this committee, Health and Human Services, may be involved going forward?
Rep. Cross, I believe he mentioned that we will be reviewing the information once we receive it after the subpoena is answered, which you can answer.
Sure. I mean, I anticipate that assuming the committee authorizes me to move forward with this, that I will finish the subpoenas fairly quickly and try to have them released fairly soon with a response date fairly quickly. What I meant when I answered that question before is what is returned, it will not just be for me to review. People will have the ability to review the materials that they provide. And we will, whether we handle that before the end of session, which admittedly there's only about 25% of our 60-day session left, whether we handle it in interim committee weeks or whether we handle it next session, I think those are issues to be decided. But we want to go ahead and request this information or subpoena this information. It's not a request.
Rep. Gant, one last question. You're recognized, and we're going to move into debate, members.
Thank you, Mr. Chair, for your recognition. Given that we haven't seen the subpoena yet, what is the time frame for compliance with the subpoena? Is it before the end of session? What is the time frame?
You're recognized.
Thank you. While again, this only authorizes me to draft it and present it to the speaker for approval, I would hope to issue the subpoena within 24 hours, and I would hope that the speaker will approve in that subpoena that those materials be provided prior to the end of the session. So that is the time frame that I'm going to be working.
Very good. Members, we're moving into debate. Any debate on this issue? Debate. Ranking Member Skidmore, you recognized.
Thank you, Mr. Chair. I understand that the authority is given to one person to write the subpoena, but we're being asked to vote on whether to allow that one person to write the subpoena without really a lot of intelligence on what that's going to include. What is it that we are going to be compelling these two organizations to provide to us? And if indeed these are the only two organizations that we will use this authority over, can at some point you now have all this authority? Is it unlimited in the number of subpoenas that can be issued? I don't know. I don't think that getting the information at 4:30 yesterday and hearing this motion today has given me or many of our members legitimate time to understand this process, feel like we have totally weighed in on it, we understand all the consequences of it. And so I absolutely cannot support the motion with this limited information, this limited time frame, this rush to send these subpoenas 2 weeks before the end of session and then compel these organizations to drop everything they are doing and provide this information before we actually sine die. I think it's unrealistic, and I think that you're putting our members in a difficult position to vote on something they can't see, they can't read, they don't understand the impact of, the far-reaching impact of, and I would urge my colleagues to vote no on the motion.
Further debate. Right? Let's go with
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I find it a little bit strange that we are debating on powers that this legislature already has when we are asking for information that should have been provided to us during the committee process. If there is something wrong with the bill that we passed, I would think that the organizations that we are asking to send this information to us would be forthcoming with it right away. I don't see why that would be a problem, why that would be an issue, why that would be something that would tax those organizations. They certainly were getting information out prior to the bill saying that this was scientifically, the best way to go. This was best practices. I don't think that it is onerous to ask them to come up with the information that they were basing those statements on. If it turns out that their statements and their scientific data contradict what we passed, then it behooves us as a legislature to act on that information. And I am anxious to take a look at what they send us. So I am up on this motion. Thank you.
Representative Gant, you're recognizing debate.
Thank you for your recognition, Mr. Chair. I have a few concerns. I'll start with the precedent that we're setting. So there's ongoing litigation, and we're now with pending motions for requests to produce that could be the same information that's the subject of the subpoena, but we don't know because we haven't seen the subpoena yet. So the muddling of the separation of powers is one of my first concerns. And what precedent are we setting by issuing the subpoena, especially after we've already taken the steps of the bills that address this issue going through committee and then passing the House floor. While I understand it hasn't been signed by the governor yet, we've gone through that process for organizations that we didn't even invite to come to provide us with that information. So that concerns me. Then when we talk about due process, as Chair Fine stated, we do have the enforcement power of 90 days of imprisonment and then a $1,000 fine. So when we're talking about life and liberty, those issues of due process are definitely a concern. And then when we talk about jurisdictional issues, if we are requesting information from the Florida chapter of a national organization, how would we be able to enforce that to a national organization? And will we then subject ourselves to further litigation? Well, I understand that statute and rule allows us pretty broad scope of investigating issues. It seems like we put the cart before the horse in this particular matter. And I just have very serious concerns about is this reminiscent of the Johns Committee and how they went searching for different things and to no avail, and to the expense of the time of the legislature and even expenses of the taxpayers. And so we had the opportunity to, one, invite these organizations to come before the committee to speak before the committee, but we didn't do that. So those are my concerns, and I urge everyone to take into serious consideration what issuing this subpoena would mean and what precedent we will be setting, given that there aren't examples of this happening in the legislature that we can draw from, and there isn't a robust body of case law when we're discussing this type of procedural process where we have already passed in our chamber a law concerning this issue, then going back and doing the investigation, and then with two very specific organizations when we have a lot more organizations that we can get more information from to really have an informed body of information to make our decision as a committee. Thank you.
Thank you. Rep. Anderson, you're recognized in debate.
Thank you, Mr. Chair. I'm no attorney, and I don't pretend to be one. So I think, as many of us here would need to defer to our staff attorneys and attorneys of the House to confirm our legal authority here. But what I do know is that we have a situation here that affects the minors in this state. It affects our children. A situation that, in my opinion, is child abuse. And when we have this type of situation, it's our responsibility as human beings to leave no stone uncovered when we're trying to find answers. So, Chair, not only do you have my support, I'm happy to volunteer my time outside this committee to work on this matter should you need it. So thank you for bringing this up.
Further debate? Members, any further debate? All right, well, I'll just say, in Florida, ladies and gentlemen, there's about 2,600 members of the Florida chapter of the American Academy of Pediatrics and a little over 1,300 members of the Florida Psychiatric Society. I would think each one of those physicians would want to know the standards of care that their organizations support relating with the treatment of minors. The information we're asking should be something that they're more than willing to give us. The fact that there's so much suspicion over it makes us even more, I would say, interested in getting it. There's an old adage where there's smoke, there's fire. Well, there's been a fire burning in this issue for quite a while. And fortunately, this House and our colleagues across the rotunda are going to put it out. Chair Fine, you recognize the close.
Thank you, Chair Masulo, and as always, being my partner in working on this. I want to address some of the comments that were made. You know, I find it fascinating that many of those who have said that this legislature is doing the bidding of the executive branch, that we've given up our right to be an independent branch, that we just take orders, now believe that we should stand by and do nothing while another branch of government does something. You know, we should not subvert ourselves to other states. We should not subvert ourselves to the executive branch. If this is something that is important to us, we should do it. And by the way, while I will grant we don't do this that often, it's something in general I think we should do more of. If you look at Washington, D.C. and how they function, about 80% of what they do in Washington is sort of investigating and holding people accountable. Only 20%, if we're lucky, is actually passing laws for the betterment of society. We don't do enough of this, and I think it has something to do with the way that we are structured. But this is a subpoena. These subpoenas will go out to 2 organizations. It's not an open-ended thing, as people said. I don't have the discretion to go and file them to others. It's these 2 organizations. This was properly noticed using the rules of the House that I believe that we all voted for. This is in our rules. It allows us to do this. It's done under the notice period that we have done. But I'd also note that this comes after a little bit of a test. These entities that so vocally and openly and proudly proclaim that if you do not follow these views, you do not believe in science, they're both based in Tallahassee, not too far away from here. And they had multiple opportunities to come and share their views with us. And by the way, I'd been fully prepared, if they had done that, to lean in and ask why. They didn't come. And again, if it's such a good idea, why would you not have come and taken on Chair Masulo and I and told us why we're so wrong and why the science is so clear? But they didn't come. By the way, they both could have come here today. They're not. And we learned this to some degree in another example, and Chair Masulo will remember this, and I don't want to belabor the point, but we did see this in a much smaller case, and I'm not going to name the organization because I don't want to beat them up, but there was an organization that came and spoke before this committee when we heard this bill, and they represented that everyone in their organization believed that what we were doing was wrong. And when myself and Representative Salzman and others sort of peeled back the onion, what we found is they were speaking out of turn. They were making representations of a position that was not, in fact, held by their membership. It is important for us to look into this. And so I want to close with this. Part of what we're doing here is we're looking at an organization called WPATH. This is the World Professional Association for Transgender Health. This is the entity that has pushed this, rightly or wrongly, which we will find out, on all of these entities. And I want to read you a couple of things that they had done. First, I want to read you from one of their former chair of their Standards of Care Committee. He was the chair 25 years ago, but he was the chair of their Standards of Care Committee. And he said the following in an expert opinion in the ongoing lawsuit. He said, quote, WPATH claims to speak for the medical profession. However, it does not welcome skepticism and therefore deviates from the philosophical core of medical science. There are pediatricians, psychiatrists, endocrinologists, and surgeons who object strongly on professional grounds to transitioning children and providing affirmation in transgender identity as the first treatment option. That's someone who used to work with them. Yet again, we're supposed to be told this is widely accepted, universally held, scientifically backed. And then the last point I would make on this to show this is there was a hearing last year at a conference where the co-author of the current standards was asked why in your scientifically backed, universally held, deeply researched standards did you eliminate the minimum age for so-called transgender care? Say you eliminated the standards. You said a 1-year-old could get this, or a 2-year-old, or a 3-year-old. Why did you show us the science? The universally held, well-researched, if you disagree, you're a bigot, science. And the person answered, well, we were thinking, and it was scary for me, about the potential uses of the chapter for legal and insurance contexts. What we didn't want to do is create a chapter that would make it more likely that practitioners would be sued. Actually, right there, they admitted it. It had nothing to do with science. It had to do with, well, we want doctors who do this to not be able to be sued. There are legitimate questions about the so-called science. And what I don't like in debates is when people use these things as some sort of stick. Well, so-and-so said it, and it's universally held. Well, it turns out it's not. And these organizations should welcome this. We shouldn't have to do these subpoenas. They should want us to see their science. They should want to show why we're wrong. But they don't. And that should raise a question. And that's why we should look into this. And for those of you who think that the bills that we're passing and the things that we're doing in order to protect our children, that we're done, I got news for you. We're just getting started. And with that, I close.
Having closed on his motion, Sabrina, please call the vote.
Representatives Persons Mullica, Salzman,
Yes.
Skidmore,
No.
Amnesty,
Yes.
Anderson,
Yes.
Baker,
Yes.
Clemens,
Yes.
Cross,
No.
Dunkley,
No.
Edmonds,
No.
Gant,
No.
Grant,
Yes.
Foster,
Yes.
Masula,
Yes.
Lakin,
Yes.
Rizzo, Snyder,
Yes.
Trabuzzi,
Yes.
Woodson,
No.
Yurkowski,
Yes.
Chair Fine,
Yes.
13 yeas, 6 nays.
Thank you, Sabrina. Members, by your vote will show that motion adopted. I'm turning the gavel back over to Chair Fine.
Thank you, Chairman Sulo.
Mr. Chair, may I make a motion?
You can.
Thank you. I make a motion to add the following organizations to as a subject of the subpoena of the previously adopted motion: the American College of Pediatricians, Society for Evidence-Based Gender Medicine, Christian Medical and Dental Associations, Catholic Medical Association, Nemours Children's Hospital of Jacksonville, Florida Catholic Medical Association, Orlando Catholic Medical Association, University of Central Florida Catholic Medical Association Students Guild, American Association of Physicians and Surgeons, St. Gianna Guild of North Central Florida of the Catholic Medical Association, and all records of ACA that they use to develop and produce the June 2nd report on gender dysphoria, which is the basis of their ruling. And that is a motion.
Thank you. And just for everyone's benefit, would you mind reading it again and just sort of clearly sharing every organization? Because we have to handle this motion the same way we handled my motion. And you guys will you're proposing to give me a whole lot of power here. So I want to know all the organizations that I would get to write subpoenas up so I can decide whether I think it's a good idea or not. So could you let me know all the organizations I'd get to subpoena with the speaker's permission?
Okay, thank you, Mr. Chair, and I can provide you with a written copy of this. American College of Pediatricians, Society for Evidence-Based Gender Medicine, Christian Medical and Dental Associations, Catholic Medical Association, Nemours Children's Hospital of Jacksonville, Florida Catholic Medical Association, Orlando Catholic Medical Association, University of Central Florida Catholic Medical Association Students Guild, American Association of Physicians and Surgeons, St. Gianna Guild of North Central Florida of the Catholic Medical Association. All records used by ACA to produce their June 2nd report on gender dysphoria, which is the basis of their ruling.
Thank you. If you do have it printout, I'd love a copy. Maybe I couldn't, I tried to write fast.
I can provide it.
But I just want to make sure, so we know the organizations. I'm just trying to clarify the motion, then we'll get to questions. So you want, okay, so I can just read it then. You want us to subpoena these, what exact, so again, I had to, in my motion, say what it was I was subpoenaing about, the endorsement of gender-affirming care as the standard of care for minors. What exactly, as I write my subpoena for these 10 organizations, do you want me to be subpoenaing them about?
The same subject of the 2 named organizations that you previously mentioned.
Okay, so your contention that these organizations have adopted and endorsed, quote, gender-affirming care as the standard of care for minors?
No, that is not my contention,
So that's
Mr.
not
Chair.
the same then as my motion. That's I need to know the scope that you want me to. So you're asking me. I'm trying to get to, look, you're going to get a full hearing here, but I think people need to understand it. So you're asking me to write subpoenas on the adoption and endorsement of standards that these groups you're telling me don't have. So what exactly am I supposed to do with this then?
Thank you, Mr. Chair, for that question. My motion is to subpoena records that these organizations have that have challenged have researched or challenged the standard of gender affirming care. That is the basis of my motion.
Okay, so to help you out, I'm going to sort of kind of restate it for you, and you tell me if you don't like it. You want me to do subpoenas that investigate basically the rejection and non-endorsement of gender affirming care as the standard of care of minors. You're saying these groups all don't like it, and so you want me to ask them for documents that show the science for why they do not.
That's correct,
okay,
as well as ACA's records that they use to develop their June 2nd report.
Okay, so there's 10 entities and then ACA. So now that we sort of understand what we're doing, we will move on to questions. Chairman Sulo's chomping at the bit. You're recognized.
Thank you, Mr. Chair. And one of my questions was whether or not, if Representative Gant, if you knew which of those organizations had adopted WPAS standard of care, which is the scope of these subpoenas. And my second question, since you were so good at giving 2 at once, do you know which of those organizations are based in Florida, which is our jurisdiction to be able to subpoena?
You're recognized.
Thank you, Mr. Chair. Thank you for those 2 questions, Chair Masulo. And my answer to both is I do not have that information, but I can follow up with you.
Thank you. I'll ask her. Go ahead. I'll save me for last. Representative Snyder, you're recognized.
Thank you, Mr. Chairman, and thanks for the motion, Representative. I'm just curious, have you spoken with anybody at ACA about the request of the information you're looking for?
You're recognized.
Thank you, Mr. Chair, and thank you for that question, Rep. Snyder. I have not.
Oh, you're recognized.
Thank you, Mr. Chair. What about any of the individual organizations that you mentioned? Have you reached out and asked them to provide any of that information, or are you just wanting to move right to the subpoena?
You're recognized.
Thank you, Mr. Chair, and thank you for that question. I believe our staff has, and as the subpoenas have not been written or we have not seen the subject of the subpoenas, that is also a basis for making my motion.
Okay, you're recognized.
Thank you, Mr. Chair. I think just 2 more questions. Of the organizations that you mentioned, aside from ACA, how many of those are faith-based organizations?
You're recognized.
Thank you, Mr. Chair. A number of them are, I believe.
And just final question.
6. Yes, you're recognized.
Does your motion specifically target faith-based organizations?
You're recognized.
Thank you, Mr. Chair. No, they do not.
Yeah, and it's 6 of the 10 say 5 of the 10 say Catholic in their name, and 1 of the 10 says Christian in their name. So it's 6 of the 10. Leader Grant, you're recognized for question.
Again, it's not a target though.
I'm not saying it is. I just wanted to, since I have the benefit of having the list and nobody else does, I just wanted people to know. But not all 10 have a religious name in them. 5 of the 10 have Catholic, and 1 of the 10 says Christian. You're recognized.
Thank you, Mr. Chair. Representative Gann, do you know how many subpoenas the Florida House has requested in the past 10 years?
You're recognized.
I would say that's no, Leader Grant. I do not know, but I would be open to you sharing that information to me.
Follow-up?
Yep, you're recognized.
Do you know if in the past 10 years when the House has asked for a subpoena, has it been done because the organization they subpoenaed was not forthcoming with information that was requested during the committee or during the legislative process?
You're recognized.
Thank you, Mr. Chair. I think that's beyond the scope of my motion, but I don't know that answer, Leader Grant, but I would be more than open to coming to speak with you about it.
Okay, I think Representative Travolta, you had a question.
Thank you, Mr. Chair. Thank you for bringing this motion. My question is pertaining to the American Dental Association. Did your staff, did you bring forth that particular association for any particular reason? I'm not sure how they pertain to gender affirming care.
You're recognized.
Thank you, Mr. Chair, and thank you, Chair Trabosi, for that question. It is based on conversations with staff that the organizations on this list have appeared to participate in the standard of care discussion and have opposed gender affirming care.
Additional questions? I got a couple. Thank you for giving me the list. Is the American College, we got a lot of concern of, are we going outside the state? Are we exceeding our authority? And those were actually very good and very fair questions that you all asked. And now you propose this, so I want to make sure you have the same concern. Is the American College of Pediatricians based in Florida?
Thank you for that question, Mr. Chair. They have members in the state of Florida. I can double check regarding their headquarters, but as the motion that previously was adopted has chapters, I believe that is applicable to this organization as well.
Thank you, and they don't. We would have actually sent them, and so we'll put that on the list, but they do not. Again, we're not doing any Americans. These are all Florida chapters. That one does. The next one, the Society for Evidence-Based Gender Medicine. Are they based in Florida? Again, we had this, I heard a lot of legitimate, good questions of concern by Democrats that we were going outside the scope of the state. So is the Society of Evidence-Based Gender Medicine based in Florida?
Thank you for that question, Mr. Chair. It is based on my understanding they have members in Florida.
Okay, members is not, we can't subpoena members, we can subpoena an organization. So are they based in Florida? We're not, you haven't asked to issue subpoenas to members of the organization, you've asked to subpoena the organization. So I'm asking, since I'm the one who would have to do this, is the organization you're making a motion to subpoena based in Florida? That's the second one, Society for Evidence-Based Gender Medicine. Are they based in Florida? Some of them are, I'm not gonna ask this for all 10, but I don't know. Are they based in Florida?
I can get back, thank you, Mr. Chair. I can get back with you with the concrete answer. It is my belief right now, which is not 100% certain, that they do have a chapter in Florida. Okay. But I can find out.
So follow up, so if they have a chapter based in Florida, then why have you not proposed that we send the subpoena to their chapter as we did in our subpoenas? That wasn't my question of do they have a chapter, it was, again, if you look at who we're targeting, we're not targeting the American Academy of Pediatrics. Our subpoenas will go to the Florida chapter. So is there a Florida chapter of the Society for Evidence-Based Gender Medicine that has an agent that we could deliver, that I could deliver a subpoena to?
Again, thank you for that question, Mr. Chair. Based on the responses in the previous motion, I would echo your responses to my questions regarding their chapters or whether they have had chapters in Florida. So I can get back with you to confirm the chapters in Florida, but it is my belief that they do have a chapter in Florida, which can be the recipient of a subpoena.
So do you want to withdraw your request and then come back to us with an entity? Or five of these, I'm guessing, are not based in Florida. The Christian Medical and Dental Associations, the Catholic Medical Association, and the American Association of Physicians and Surgeons. The other ones sound like they would be based in Florida. Do you want to withdraw your motion and come back if you can come up with Florida chapters for these motions? Or is it your belief that we should file illegal subpoenas to national organizations that aren't based here in the state of Florida?
I would not like to amend my motion, and it is not my contention that we should issue any illegal subpoena from this body. I have Googled the American College of Pediatricians, and they do have a chapter in Gainesville, Florida. So I can confirm that right now.
Okay, but again, we'll move into debate. That's not what your motion here says. All right, so members, I'll be done asking questions. Is there any debate on the motion? Or actually, are there any other questions? Well, I was last, so Chairman Stulo, you're recognized in debate.
Thank you, Mr. Chair. I would ask all the members to vote down on this motion. First of all, for two reasons. Number one, we've established that the sponsor isn't aware of which organizations actually are based in Florida, and many of which are not. Number two, the motion is really outside of the scope of the investigation by which we're trying to gain information, which was those organizations that actually agree with WPATH on the standard of care for minors regarding gender-affirming care. And lastly, I believe that many of those organizations listed are not necessarily medical organizations. They're organizations by which some physicians may be involved, but there could be others involved as well, and those others would not probably be within the scope of what we're trying to ascertain. And for those reasons, I would ask that everyone vote down on this motion.
Additional debate. Yes, Leader Grant, you're recognized.
Thank you, Mr. Chair. I asked Representative Gant a question about how often subpoenas were issued by this body of the Senate for a reason, because it's very rare. And it's very rare because we typically would only do that if we thought somebody was being disingenuous when they were providing testimony or didn't provide testimony but were making public statements that opposed or were in favor of legislation. I think to go, as Representative Gant said, that she was proposing this motion for these subpoenas because these individuals, 10 entities, were in favor of this law, leads us to a very slippery slope. If we're going to subpoena everybody that provides testimony to us, that's great. I think that would make the process a lot easier, but I don't think that's really where we want to go. We want to hear people's opinions, whether they're factual or not. If we think they're lying, we can determine that by ourselves, but when organizations come and refuse to provide information to us, I think it is our right, and though rarely used, to go out and ask those people for that information and what they're basing their decisions on or their opinions on. And so I would ask you to vote down on this motion because I think we should, at this point, keep subpoenas very rare in this legislative process.
Additional debate. All right, seeing none, I'm just going to close by saying this. I suspect that these organizations would be happy to tell us why they believe what they believe if they were simply asked. And I think I actually have met with a number of them who have told me why. So again, I don't know that we need to do this sort of thing. They are not the organizations that are proposing these kinds of surgeries and castrating drugs on children. It is something to be dealt with before. With that, you're recognized to close on your motion.
Thank you, Mr. Chair, and thank you to all the committee members for your engaging questions. So, I like to say old sayings that my grandmother had, and what's good for the goose is good for the gander. If we are taking this rare step to issue a subpoena, one that this committee, or subpoenas that this committee has not seen yet, then we should have a full broad spectrum of research-based information to make our determinations on. These organizations have opined that they are against gender affirming care. And so in order to fully understand the subject, because I am not a doctor, I would like to see all sides of the argument. And that's just from, a research-based approach. Both sides can present facts and research-based information to this committee so that we have the ability to make informed decisions. And I do agree with Leader Grant, your position of keeping this subpoena process rare, but we also have to ensure that it's a fair process, because all of us on this committee have been elected by Floridians from all walks of life. And we are here tasked with the duty and responsibility of making sure that we are walking in step and in line with ensuring that all of our constituents are represented. And so if we are asking for information from an organization that supports gender affirming care, then we should get information from organizations who have presented opinions about being against gender affirming care. Additionally, my position is that the basis of my motion is that we should not mimic what happened in the Johns Committee, where it turned into a witch hunt for particular organizations. And if we have appointed reason for these subpoenas to be issued, then we should be thorough in ensuring that all aspects of this investigation are illuminated and there's no stone unturned. So I would ask you all to support this motion so that we have a fair and balanced breadth of information to evaluate our position from. So with that, I thank you for entertaining this motion, Mr. Chair, and I close.
Members, we're going to vote on the motion to issue subpoenas to these 5 out-of-state organizations and 5 in-state organizations. Sabrina, please call the roll on the motion.
Representatives Persons Malika, Salzman,
No.
Skidmore, Amnesty,
No.
Anderson, Baker, Clemens,
No.
Cross,
Yes.
Dunkley, Edmonds,
Yes.
Gant,
Yes.
Grant,
No.
Coster,
No.
Masula,
No.
Lincoln,
No.
Rizzo,
Nope.
Snyder,
No.
Trabuzzi,
No.
Woodson,
Yes.
Yarkowski,
No.
Sherfan,
No.
4 yeas and 12 nays.
Show the motion defeated. Okay, unless we have any more of that, we are going to return to bills. We have 3 left and all 3 sponsors are here. We're going to start with CS for HB 1413, healthcare expenses by Representative Tremont. Representative Tremont, you're recognized to explain your bill.
Thank you, Mr. Chair, Vice Chair, Ranking Member, Speaker Clemens, and Leader Grant. Members of the committee, it's an honor to stand before you to present House Bill 1413 related to healthcare expenses. This bill passed the House floor twice the last 2 years, unanimously last year. Again, it calls for price transparency for shoppable services, requiring licensed facilities to provide an estimate of charges to the patient and to the provider when the medical service is scheduled. It requires insurers to give patients advanced explanation of benefits and an estimated out-of-pocket expenses with an appropriate deadline to adhere to. Finally, it expands medical debt exemptions and establishes a statute of limitations on debt collections and implements a grievance process for patients to dispute the charges, and that is the bill.
Thank you. Having explained the bill, members, are there any questions on the bill? Seeing none, is there any, do we have any public testimony? I don't think we do. No public testimony. Members, anyone wishing to debate? All right, seeing none, you are recognized to close.
I wait close.
All right, Sabrina, please call the roll on CS for HB 1413 and announce the vote.
Representatives Persons Malika, Salzman,
Yes.
Skidmore, Amnesty,
Yes.
Anderson, Clemens,
Yes.
Cross,
Yes.
Dunkley, Edmonds, Gant, Grant,
Yes.
Coster,
Yes.
Masula,
Yes.
Lakin,
Yes.
Rizzo,
Yes.
Snyder,
Yes.
Trabuzzi,
Yes.
Woodson. Yes. Kirkowski,
Yes.
Chair Fine,
Yes.
15 yeas, 0 nays.
All right, so show the bill reported favorably. Thanks for waiting. Next, we're going to have Representative Williams present CS for HB 143, Task Force on the Monitoring of Children in Out-of-Home Care. You're recognized to explain your bill.
Thank you, Mr. Chair, Vice Chair, and Ranking Member. CS for HB 143 creates a task force within the Florida Department of Law Enforcement to identify and address the root causes of why children go missing while placed in out-of-home care in the state child welfare system, which will be the foster care system. This task force will examine current policy, procedures, and program and recommend improvement to provide children from going missing while in out-of-home care. Mr. Chair, that's the bill.
Okay, are there questions on the bill? Seeing none, we do have some public testimony on the bill. There are no amendments. First, we're going to have Barney Bishop representing the Florida Smart Justice Alliance, waves in support, and Karen Mazzola, waves in support, from Florida PTA, waves in support. Members, is there anyone wishing to debate? Representative Grant, you're recognized.
Thank you, Mr. Chair, and thank you, Representative Williams. I know your passion for this subject. Some of us talk, some of us walk. You walk, and you're one of my heroes in this process. You have been since we got elected back in 2016. So thank you for bringing this forward. I am definitely up on this bill.
You're recognized to close. Is there any, Representative Trabulsi, you're recognized.
Thank you, Chair Fine. Representative Williams, thanks for bringing this bill forward. I know you have a huge heart for children, and I appreciate you adding just one more layer of protection to our kids that are most vulnerable in our state. So thank you so much.
Representative Masula, you're recognized.
Thank you, Mr. Chair, and I'm going to concur with my colleagues. I'm not sure of the need for this bill because most of those kids are probably at your house. But I think your efforts, particularly for those children that don't have parents, has been exemplary in all the years that I've known you. And I'm strongly supporting your bill.
Okay, Representative Woodson, you're recognized in debate.
Thank you, Mr. Chair. Williams, thank you for bringing this great bill forward. One thing about you when it comes to the children, you always look at an issue and always decide to do something about it. And this is exactly what you're doing with this. Remember during COVID, we had a lot of those kids that we could not trace. We didn't know what happened, and not just during COVID, it's always been an issue. And you are bringing a solution to this problem. And I really appreciate your work on that. This is your passion, this is your heart. I will definitely miss you once you leave the legislature. This is your last term. Thank you so much, I appreciate you.
Anyone else wishing to speak in debate? Seeing none, you are recognized to close.
Thank you, Mr. Chair. And this is just an extra eye to keep our children safe, and that I close.
Thank you, and you're gonna have to stand there for a minute. Members, we are going to do a quorum call. Don't go anywhere. We have to wait for a while to look at me. So, members, I don't mind sharing this. We have to have 15 people in order to vote on Representative Williams.
I can talk while.
No, it's all right.
I have additional information on this bill that, you know.
So anyway, no, we're, okay. All right, we've got 15. We're good? Okay. Sabrina, please call the roll on CS for HB 143 and announce the vote.
Representatives Persons Malika, Salzman,
Yes.
Skidmore, Amnesty,
Yes.
Anderson,
Yes.
Baker, Clemens,
Yes.
Cross,
Yes.
Dunkley, Edmonds,
Yes.
Gant,
Yes.
Grant, Coster,
Yes.
Masula,
Yes.
Lakin, Rizzo,
Yes.
Snyder,
Yes.
Trabuzzi,
Yes.
Woodson,
Yes.
Yurkowski, Chair Fine,
Yes.
15 yeas, 0 nays.
All right, show the bill reported favorably. 16 yeas. 16 yeas, show the bill reported favorably. All right,
Thank
congratulations.
you, Mr. Chair and committee members.
Thank you. Next up, we have our last bill, and again, I would remind members, I know we've got a lot going on. I'm presuming that conference notices are coming in and out as we sit here, but if we do want to get this last bill done, we do have to maintain a quorum, and I think the sergeant's about to start calling people, so you don't want to be one of them. So with that, we're going to bring up our final bill today, CS for HB 1509 on prescription drugs by Representative Cheney. Representative Cheney, you are recognized to explain your bill.
Thank you, Chair Fine. Thank you, members, for hearing my bill. HB 1509, the Prescription Drug Reform Act, brings transparency and accountability to the way pharmacy benefit managers, or PBMs, operate. The bill also expands consumer choice, increases competition, and supports small business. Specifically, the bill prohibits spread pricing, clawbacks, steering, and establishes conditions for mandatory mail order, requires 100% of drug manufacturer rebates be passed to the plan or program for the sole purpose of reducing co-insurance and premiums, brings transparency to the opaque industry by requiring reporting from the PBMs and drug manufacturers, including guidelines for reporting drug price increases and reasons for the increases,